Hello everyone, I'm a lawyer from LPA Singapore and today I'm going to speak about managing a global workforce. Why managing a global workforce is a relevant topic? Who is concerned? What are the legal implications? The trend, although it has slowed down with the COVID-19 pandemic, is the growing of global mobility. Increased cross-border activities and connectivity with increased security concerns and personal scrutiny, increased communication and exchange of information between states have effects for companies and can lead to loss of business, bad reputation, loss of investment, and multiple legal risks. There are long-term expatriates, 2 to 5 years usually, short-term assignees, 1 to 2 years, the so-called accidental expatriates, such as regular business trippers, short-term assignees from a few weeks to 12 months, project-based employees, and often neglected, the multi-state employees working in several countries. Managing a global workforce consists in managing the risk involved by the global mobility of employees in a changing legal environment. The following polygon can help you assessing the related legal risk. First, immigration, second, employment law, then social security tax, income tax and corporate tax, pension issues and international laws applicable must be assessed as well. National law governing immigration at the place of activity and at the place of residence are the first set of rules to comply with and to verify prior to departure for outbound assignees and on arrival for inbound assignees. No choice of immigration law is possible for employers and employees. On the contrary, national law governing employment can be chosen in the employment agreement and sometimes the competent jurisdictions. But this is provided mandatory provision and public order rules of the place of activity are complied with. Existence of privilege of jurisdiction should be verified as well. National law governing social security tax cannot be chosen. In principle, the law of the place of activity is applicable. In some countries, both parties to the employment agreement can decide to apply the home country law on a voluntary basis. Extraterritoriality of home country's legislation should be verified and whether a social security tax treaty is applicable or not. National law governing income tax cannot be chosen neither by the employer and the employee. In principle, the law of the place of activity generating the income is applicable. However, one should consider whether or not a double tax treaty is applicable and if conditions are met or not. Corporate tax law implication and the risk of permanent establishment should not be neglected. The key questions to ask are: does the nationality matter here? Is a work permit and residence permit required? What contractual scheme to choose? Home contract, assignment letter, or local employment contract? How to protect the company from claims and costs? Is there a social security tax liability? Are filing obligations required? Tax withholding, payroll obligation, tax equalization? What is the job description of the assignee? Is the home contract maintained? Does a branch, representative office, or subsidiary exist in the host country? The key takeaways are: do proceed to an audit or review a sample of staff members who are assignees. Do review the company's handbook, company's policy. Do check the employment agreement or addendum of assignees. And above all, do keep in mind the polygon. Thank you for your attention. À bientôt!